Professor Blackman, I am sure that many of you are familiar with. Anyone who's been involved with the Federalist Society or attended FedSoc events has come across Professor Blackman's work before. He's a professor at South Texas College of Law, and just one of the most prolific writers I've ever seen. And multiple judges that I clerked for all relied on Professor Blackman's writing, and that's true for many other judges, many other lawmakers as well. I was looking over your bio, and I didn't realize that you were quoted in 2 impeachment trials.
Both of them, yeah.
That's 2 out of 2 in recent years, so
yes.
That's a lot of fun.
Andrew Johnson, is that the one?
Yeah, Andrew Johnson.
I am not that old, but actually the Samuel Chase impeachment trial will go way back.
So, Josh, or Professor Blackman, he's been in every print publication that you can think of. He writes for Reason. He has blog posts. You don't even know that there's a legal issue, and he's already written about it. So it's a real joy to have him here today. I think what we originally had talked about was the president's executive orders on immigration, but there's been so much going on since we originally planned this event. I think we're generally sticking to executive orders.
We'll stay there,
and,
yes.
And we'll talk about the president's authority. And please feel free to, whatever topic you think is appropriate. We have an engaged group, so we look forward to discussing with you. Thanks for being here, Professor Blackman.
Thank you so much. I spoke at St. Mary's before, but not to your chapter. It's a pleasure to be here. There's a lot to cover, and there isn't very much time. What I'll try to do is divide the Trump orders into 5 categories, 5 buckets. The first is the removal power, the president's power to remove people within the executive branch. The second is birthright citizenship, that is whether a person born here to illegal aliens is a citizen at birth. The third is a law that you've never heard of, but becomes very important, is the Alien Enemies Act. This is a law passed in 1798 to give the president the power to remove aliens of enemy nations. Number 4, DOGE, and the president's power to cut spending. And then number 5, the firing of civil servants, particularly probationary employees who have only been in the government very recently. And I'll close with some broader thoughts about where we are. Is there a crisis? Is there a conflict? Is it a crisis caused by Trump? Is it a crisis caused by the courts? Or maybe a little bit from column A, a little bit from column B. All right. So let's start off with the removal power. The Constitution has a pretty clear method of how people are appointed, right? The president makes a nomination, and the Senate provides advice and consent. That much is clear. But the Constitution is silent on how. Ooh, can we kill the music actually?
Yeah, we're working on that.
Okay. Yeah, I'm hearing some Sinatra as I'm trying to talk about Trump, which is it's actually very fitting, I guess. So the Constitution, though, is actually silent about how a person can be removed. From very early on in 1789, a precedent was set that the president has the power to remove without seeking permission of the Senate. This issue was litigated not in the courts, but in Congress. You mentioned Andrew Johnson a moment ago. Why was Andrew Johnson impeached? Well, of course he opposed Reconstruction, but also he fired the Secretary of War, Lincoln, over that permission from the Senate. That was actually the major basis of his impeachment. He was ultimately acquitted. He was not convicted in the Senate. So the rule became the president can remove people. Okay, but then there were some cases in the early 20th century that changed direction. The case called Humphrey's Executor. Remember this one from law school? Humphrey's Executor involved the FTC, the Federal Trade Commission. President Roosevelt tried to fire a member of the FTC. The Supreme Court said, no, you cannot do that. These so-called independent commissioners can only be fired for cause. That is, neglect, abuse, fraud, something else that's bad. Okay. Fast forward to 1988. We have a case called Morrison against Olson, a case that you might recall. This involved the special counsel, and there the court upheld this broad power of this investigator who could not be fired at will by the president. So these precedents have been in the books, Morrison and Humphrey's Executive, for many years, saying that the president's power removal is limited. For years, for decades, conservatives said we need to challenge Humphrey's Executor. We need to restore the president's power to supervise the executive branch and accountability. Yet Reagan didn't challenge it, and Bush didn't challenge it, and the other Bush didn't challenge it, but Trump did. Within literally days of his new administration, he fired just about everyone. I'll just give you some of the agencies he fired people from. The NLRB, the National Labor Relations Board, he fired a commissioner, a member there. He fired the Democratic members of the Federal Trade Commission. He fired members of the MSPB, Merit System Protection Board. He fired members of the EEOC, the Equal Employment Opportunity Commission. He fired everyone. He fired people of agencies never heard of. And in almost all these cases, there was a statute saying, you cannot fire these people at will. Trump handed them a one-sentence letter saying, you are being removed, thank you for your service. I shouldn't say thank you, but saying, you are being removed, period. That's it, without any explanation. He didn't thank them, though. I made that last part up. So almost immediately, the people ran to court. Now what's curious, in the past when the presidents fired someone, what was the remedy sought? Back pay. That is, I have a 5-year appointment, I was fired in year 2, give me my 3 years of back pay. The remedy in this case, though, was different. They didn't just seek back pay, they sought reinstatement. You'll do employment law in the room? Reinstatement's a very hard remedy to actually pull off, especially in the executive branch. Why? Who does the order actually run against? Who are they asking to recognize this person as a commissioner? The president. Can a court even issue an order running against the president? Let's go back to Andrew Johnson. Once again, the Supreme Court held in a case called Mississippi against Johnson that these sorts of orders cannot run against the president. Right? You can't issue what's called mandamus to the president. The court and the president are equal sovereign, right? They're co-equal branches of government. One's not above the other. I'll get to that point later. So the lower courts actually held consistently that under Humphrey's executor, these people could not be fired. And they ordered reinstatement of these officials. Trump said, I'm not recognizing this person, I fired them. And I cannot supervise the executive branch if I'm being told who to hire and who to retain. If they want to seek a remedy, go seek back pay. You can't order reinstatement to the position. Now this issue is actually still sort of live. When I say live, I mean it's not yet resolved. Only last week, this case came to the Supreme Court, and the Supreme Court, actually just one member, Chief Justice Roberts, issued what's called an administrative stay. What's an administrative stay? That means the chief said, I alone will put the lower court ruling on hold and let this case be briefed. What Roberts was signaling is, okay, maybe Trump can't fire these people, but you can't force the executive branch to recognize their authority.
That's going to be recognition for that.
You want to close the door, please?
Thanks. All right, I'll speak up. So the removal power cases are tricky. Will the court overrule Humphrey's executor? This is the million-dollar question. For generations, conservatives have said, we need to overrule Humphrey's executor, we cannot keep this case in the books. The court can duck the issue. What I think might happen is the Chief Justice might say, well, we won't decide whether Humphrey's executor is correct, we'll just say that whatever the answer is, we can't order reinstatement, goes to back pay. That would kick the can down the road and make these people go to the Court of Federal Claims. Court you maybe heard of, maybe you haven't. When you sue the government, that's where you go for damages. Sovereign immunity has been waived there. So I am somewhat skeptical the court overrules Humphreys, but I think at some point they'll have to confront the issue, maybe not this year, maybe in 2 or 3 years, and decide whether Congress put limitations. In a number of recent cases like CETA law, the court signaled that Humphrey was wrong, it's on its last legs, but does the Roberts Court willing to give Trump the power to remove all these independent commissioners? Taking a step back, the idea of an independent commissioner has always been sort of an anomaly. Why in our executive branch are people who are not accountable to the executive? It's never quite made much sense to me. And why do you have these 5-member boards where very often when you have a Republican president, you still have a Democratic majority on these boards? It often happens that way. Why shouldn't there be, when an administration comes in, their people are in office? All right. So that's sort of the first issue of removal power. Let's go to the second one on birthright citizenship, a topic that's been very much in the news recently. The Constitution is actually silent. The original Constitution, passed in 1787, was silent on how citizenship is determined. It says nothing at all. To be sure, if you're president, if you're a natural born citizen, that's easy. And if you want to be a member of Congress, you have to be a citizen. Okay, that's straightforward. But how does one become a citizen? The Constitution says nothing. Congress has laws regarding naturalization, but that's a statute, right? Congress is a process. What about a person born in the United States after the Constitution was ratified? Are they a citizen? There's sort of issue lurking in the background of this question with slavery, right? Why? When you are a citizen, you get rights. You get these things called privileges and immunities, these rights that are granted by the Constitution. And the states cannot deprive you of those rights. But black people were born in this country all the time as slaves. If they were citizens, they would get these rights. So what happened? Chief Justice Taney decided the Dred Scott case. And what did Taney say in Dred Scott? He said that people of African descent could never be citizens. Never. He thought it was ridiculous. Why? Because if they were citizens, they'd have rights, they get due process, and that's inconsistent with slavery. So to uphold slavery, Taney denied entire class of people their citizenship. But then we had a civil war, a bloody civil war that yielded the Reconstruction Amendments. And the 14th Amendment begins, the very first sentence, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they shall reside. There are these kind of two tiers of citizenship. There's state citizenship and United States citizenship. But if you're born in the United States and you're subject to our jurisdiction, you are a citizen. So pretty clearly this provided citizenship to the slaves, the freed slaves. That's not much in dispute. What does this phrase, subject to the jurisdiction, mean? The easy answer, one that doesn't require much work, is the children of diplomats. Imagine you're here on a diplomatic mission, and you and your wife have a child. Mazel tov, congratulations. Your child is not a U.S. citizen by birth, right? You are literally not subject to our jurisdictions. Diplomats have immunity, right? They can't be prosecuted the same way we can. There's an entire law about diplomatic immunity. That's the easy one. The harder one was Indian tribes. And there were a series of cases about this. Because the Indians, well, they're technically the United States, but they have their own kind of, their own tribal areas, what we might call a reservation, right? They have their own jurisdiction. And there were a number of cases where the court said that Indians are not given citizenship at birth. It's complicated a little bit because every reservation is a little different. To this day, Indians receive citizenship through statutes, right? There's a statutory grant of citizenship, not constitutional. We have people born in the territories, right? Puerto Rico, Guam, American Samoa, and so on. The rules here are a little bit complex, but for the most part, they are given citizenship not by the Constitution, but by a statute, which in theory can be repealed. The Supreme Court decided a very early case called Wong Kim Ark. So who is Wong Kim Ark? He was the child of Chinese immigrants. But critically, what's important here is that Wong Kim Ark's parents were what we would now call green card holders. That label didn't exist yet, but they were basically permanent residents. So they were here lawfully. So there was not much debate that even though their parents were also citizens of China, loyal to the Emperor of China, they were here lawfully. They were subject to our rules, our jurisdiction. So he was granted citizenship. After this case, it was widely assumed, in fact, most people in the executive branch agreed, that if you're born in this country, you were a citizen regardless of the immigration status of your parents. That was the consensus view. In fact, I think that's the correct view. But there was always sort of a minority view that that's not correct, that the children of illegal aliens cannot be citizens. Why? Because their parents disregarded our laws. They're not subject to our jurisdiction. They came here illegally. President Trump, in his first administration, sort of flirted with this idea. He sort of considered doing something on birthright citizenship, but he never actually did it. He said lots of things he never actually did. He's sort of doing them now. But on his very first day in office, he signs a series of executive orders concerning immigration. There were a lot of them. I can't talk about all of them. But one of them said that it's now the policy of the United States that if you are the child of an illegal alien, and even the child of someone here on a student visa, that is, you have some visa, but it's a temporary status, you are not a citizen at birth. And the order says that the United States government will not grant you any documentation, whether it's a passport or a social security card or anything else, to the child of an illegal alien. Okay, this policy was blocked almost immediately. I mean, I'm talking within hours, right? Judges in, there's one in Seattle, there's another one in Boston, one in Maryland, I've lost count. Right? Everyone sought an injunction and blocked it. The cases were appealed to the Courts of Appeals, and surprisingly, the Courts of Appeals affirmed. But then the US government filed a petition to the Supreme Court. And they did something very crafty, right? People don't quite get this aspect of the case. The judges in Boston, Maryland, and Seattle issued what are called nationwide injunctions. I'm sure you've heard about this. What is a nationwide injunction? What it means is it provides protection for basically everyone in the United States, no matter where you are, right? What if you live in Texas and Texas hasn't brought a lawsuit? You're covered by the injunction, right? These injunctions apply to people who are not parties to the case. So what did the US government ask the Supreme Court to do with regard to birthright citizenship? They said, for now, limit the injunctions to the named parties. Limit it to the states that brought these lawsuits and the various groups that are litigating this. So for example, Texas, our AG has not challenged this order, he probably agrees with it, right? So if a child of illegal alien is born here, they say that person cannot be a citizen. This is a gut check for the court. I'll explain why. Even assuming the court agrees that this order is facially unconstitutional, there's another principle. The principle is that the courts only have the power to rule over those who are properly before them. The courts cannot extend remedies beyond the parties before them. So in theory at least, if the court was being sort of consistent with their views on jurisdiction, they would grant the government's petition and limit its ruling only to those who are before the court. In fact, Justice Barrett and others have said, we don't look at the merits on these sorts of rulings. All we're looking at is the procedure, right? Is the procedure proper? Again, if the court's being consistent, they would grant the government's petition. I am skeptical because this would have an immediate effect in about 20-something states where children would no longer be citizens at birth. So what's the court going to do? I'll tell you what they've done already. Usually when you get an emergency petition to the Supreme Court, they request a response in a couple days. 1 day, 2 days, 3 days, maybe a week. Chief Justice Roberts gave how much time? 3 weeks. They are going to drag this one out as long as they can. And, I'll talk about the chief a lot more in a few moments, but he's trying to work out some deal. I don't know what the deal is. It's like, let's make a deal, right? He's trying to work something out. I don't know that there's even more than maybe 1 or 2 votes to rule for Trump on the merits, but on the procedure, this is actually a very tricky case. Okay. The third category of topics that I want to talk about today is the Alien Enemies Act. Now, if you think back to your first year of law school, when you took common law, you might have learned about the Alien Sedition Act. Does that ring a bell? Okay, the Alien Sedition Acts were passed by the Adams administration in the late 1790s. And this was designed during the so-called quasi-war with France. We were kind of at war with France, but we weren't really at war. Nothing was declared. And this was designed to punish speech in the United States that was critical of the US government. Right? Speech that was critical of the government, they could actually punish it. It was called seditious libel. The law was also broader, though. It spoke to not just sedition, but also alien enemies. What would you do with aliens in the country who are citizens of the nation we're at war with, right? If we're at war with France, for example, what do you do with French citizens of the United States? Right? In the normal course, we deport them, right? We order them removed. But if we're at a state of war with another country and we don't have diplomatic relations, how can we send those citizens back to their country? It doesn't really work. So the Alien Enemies Act is long understood to allow detention and maybe even removal to third-party countries during the state of war. During World War II, we often speak of the Korematsu case. The case was actually twofold. Matsu was a U.S. citizen, so there was different authority to detain him. But there also were Japanese aliens who were not U.S. citizens. FDR invoked the Alien Enemies Act to detain them. We cannot remove them to Japan during the war. We will keep them in these various internment camps. Alien enemies are not given all the same due process of law and all the same sorts of rights. So what did Trump do almost immediately he came to office? He designated Trinidad, I'm sure I'm saying that incorrectly, it's a Venezuelan gang. And he asserted that it's not just a private gang, it's actually been so embedded in the Venezuelan government that's effectively a state actor, right? It's effectively a state actor. So when we declare Trinidad as an alien enemy, it's basically declaring Venezuelan alien enemy. It sort of all comes together. So what did Trump do? On a Saturday, you had a number of Venezuelan nationals who have alleged ties to this gang were being held in Harlingen, not too far from here. Of course, Harlingen from here, not too far, right?
5 hours.
Yeah, 5 hours. In Texas, 5 hours is nothing, right? You go to New England, 5 hours, like 4 different states you cross, right? You're still in Texas. So they were being held in Harlingen. Why? It's in a southern state near the border. And word got to the ACLU that these aliens are being loaded up on planes to be flown to El Salvador, to their, it's called CTOT, I forget the acronym in Spanish, but it's either their terrorism prison, this massive prison in El Salvador. President Bukele built this ginormous prison there. What happened next is sort of remarkable. In fact, I don't think we have all the facts. But again, this was a Saturday afternoon. The ACLU files a lawsuit. Not in the Southern District of Texas. No, they would never do that. No, they don't. No inform shops, right? No. They filed a lawsuit in D.C. Now, there's an old rule called the custodian rule, if you ever do criminal law or habeas. Where do you bring a habeas petition? Where the custody is being held, where the alien's being detained. That is clearly in the Southern District of Texas. The courts in Texas are in fact functional. We do have functional courts here, true in fact. It's true. And they sought basically an emergency habeas petition to release these aliens. Somehow on a Saturday afternoon, the case won for Judge Boasberg, who's a federal district judge in DC. And he schedules a hearing in like an hour. It's not clear the government lawyer even knew what the heck was going on. He maybe participated, maybe didn't. I actually don't even know all the details. But the judge basically said, if any of those aliens are put on a plane, get them off the plane. And if those planes are in the air, I don't care where the hell they are, you turn those planes around and bring them back to Texas. The planes were not turned around, and these individuals were flown off to the prison in El Salvador. So let's just focus on the legal issues before we get to sort of the broader gestalt. It was pretty clear to me at the outset that the judge lacked jurisdiction, right? The aliens are being held in Texas, custody was in Texas, they were being flown from Texas, they should have been filed in a Texas federal court. This was just pretty obvious to me. This is unfold v. Padilla, the case from the early 2000s involving the Guantanamo cases, right? You bring the suit where the custody is being held. Then there's the sort of the broader issue. We always say that when a judge issues an order, it has to be followed right away. But let's just get a reality check just for a minute, if I can. You have a military mission to transport people to a foreign country. There are probably very complex plans about the routes, how much fuel you have on the plane, where there's safe passage, and so on. The judge knew none of that. Can it really be that a judge can know that planes have to be turned around midair without knowing any of these things? Okay, that's issue number one. Number two, the judge issued this order orally. It wasn't written. It's not clear to me that the people in government actually even knew what the heck the order was. At the same time the planes were in the air, he was having a hearing. Right? So you probably see in the press that the Trump administration ignored the judge. I think we have to be a little bit more careful. I think this was an unusually fast-moving set of events where it probably wasn't possible to do everything that had to be done. I think the better answer is judges, it's true, sometimes overreact. Trump has a tendency to make judges overreact. He does. And then in turn, the judges make Trump overreact. It's this vicious cycle that goes back and forth, right? They play off each other. So in an ideal world, right, where the president announces, I'm going to move these aliens in a week. Okay, you have a hearing, you have a mini trial, right, you do stuff. But when the president decides we need to move people right now, on a Saturday afternoon, it's pretty clear he did this to avoid scrutiny, right? We know why he did this. I don't know that these orders can be complied with right away. It's sort of awkward to say, but judges have to have a little more humility when they're issuing orders into the executive branch. Now, I'll give you an example. You all study in law school the steel seizure case, right? Young Sanchian 2 versus Sawyer. This is a very important decision where President Truman, as administration, took over the steel mills during the Korean War to preserve our routes of supplies, to make sure we have enough supplies to fund the war effort, right? We need to have steel for the tanks and the guns. A federal judge ruled that the steel seizure was unconstitutional. And the federal judge said, you must restore ownership of the steel mills right away. Did the Truman administration comply right away? No, they didn't. They sought an emergency appeal with the DC Circuit, but there was no stay in place. They just let it ride. And the very next day, the DC Circuit, by a 5-4 vote en banc, said, we will grant a stay if you take an appeal to the Supreme Court right away, which they did. But there was at least a 24-hour period where there was a binding court order and the executive branch did not comply. So again, I think you have to have just a little bit of humility that when you are a federal judge and you issue an order to literally turn planes around in the middle of the sky, you don't know where the hell they are, if there's no knowledge, you're a judge sitting in Washington, D.C. on Zoom, right? Just have a little bit more sense of where the world is. Now, of course, the judge knew that once these guys were sent to the prison, they're not coming back. He knew that. And I'll talk about that in another, that's a Garcia case in a minute. But I think those issues have to be separated. Now, what ultimately happened, this case involving Judge Boasberg's ruling came to the Supreme Court in a case called JGG, the guy's initials, JGG versus Trump. And what did the Supreme Court hold? There's no venue. There's no jurisdiction. This case should have been filed in Texas, where of course it should have been filed. But of course the ACLU doesn't want to file it in Texas because the courts are more conservative. So after all this, after the judge literally ordered planes to turn around, this was a case where the Supreme Court said, you don't have jurisdiction. Right? The most basic thing a court has to have to do anything is jurisdiction. A court without jurisdiction is like a day without sunshine, right? You cannot exist without jurisdiction. All right. So this was a case of blocking planes from going to El Salvador, which is a country that none of us probably even found on a map before this, but now we all know about, right? There was another case that went to Supreme Court called Noam, Christian Noam, the DHS secretary versus Garcia. Now, who's Garcia? Garcia was a resident of Maryland. He was been here for a number of years. The government alleged that he had connections with one of these Venezuelan gangs. No, actually it was MS-13. He had connections with MS-13. Okay? He was removed to the El Salvador prison, even though there was an immigration judge order saying don't remove him. The government acknowledged this was an error. They called it an administrative error. Whoopsie, right? Government makes mistakes. But then a judge in Maryland, her name is Zinnis, it's X-I-N-I-S, I think I'm saying that correctly. Judge Zinnis ordered that the alien be returned from El Salvador by a certain day, Monday at 5 p.m. And the government basically said, we can't do it, right? What you're asking us to do is to negotiate and reach a deal with a foreign sovereign, with the president of El Salvador. And the courts lack the power to issue such an order. The district court judge was basically ready to hold the government lawyer in contempt. The government took an emergency appeal to the Fourth Circuit. And the Fourth Circuit affirmed, although kind of a split opinion. Two judges said, yes, President Trump, you must return this alien right away. We don't care how you do it, you gotta do it. And then there's concurrence by Judge Wilkinson, who was a Reagan appointee, kind of a genteel moderate, who said, well, we can't force them to negotiate, but maybe they can facilitate. That's where they use facilitate the return of the alien. Facilitate. So I'm like, okay, that's what the court's going to do. In fact, that's what the court did. The court issued an order. It was basically unanimous on this line that there must be a facilitation of the removal. What does facilitation mean? The court didn't define it. This was completely predictable was going to happen. I mean, so what does the Trump DOJ tell the district court judge in Maryland? They say, well, you know what? This is a matter of foreign policy. There's some state secrets involved. There's a process. We're working on it. The judge said, I want updates every day at 5 p.m. what you've done today. So they say, no, nothing new. Nothing new to update you on, Judge. So, I mean, what's going to happen, right? Does this judge in Maryland hold President Trump in contempt? The Secretary of State, do they put him in custody, impose fines against the Secretary of State for not negotiating the surrender of these aliens? Just yesterday, President Bukele, who probably never heard of for last year, was at the White House. He was at the Oval Office, and a reporter asked him, so, are you going to release Mr. Garcia? He's like, no. I mean, you're laughing. You shouldn't laugh, but it is funny because you often think of courts having complete control over anything in government, and he's saying no. So I think this is one of these cases where the government admits they made a mistake. And we often talk in law school where every wrong there's a right. Any injury can be remedied. Except that's not really true, right? Poor William Marbury, right? Marbury against Madison. He never got his commission. And what the court says, we don't have the jurisdiction to order the secretary to return your commission. There are many cases where there's egregious acts that cannot be remedied by the courts that fall to the diplomatic process. I feel bad because Garcia, by all accounts, should not have been removed. This was a mistake in every regard. But I think we have to sort of see the bigger picture. Judges do not have the power to micromanage and superintend American foreign policy. That would be a far greater injury to the polity than, frankly, the state of Mr. Garcia. I mean that. If a judge could say, you must go to a foreign leader and then say, let my people go, sorry, it's Passover, right? You must order the release of these aliens. We are in very dangerous waters at that point.
So are you suggesting that the Supreme Court's order in that case was an example of the judicial humility that you spoke to earlier?
Good question, yeah. I think the court's order, and maybe I'll talk about this a little bit later in more detail, but the court was basically saying, we can't fix everything, and we're not going to try to. And I think the court was hoping to give Trump another chance to sort of work things out. But I don't know if this case comes back up, what the court will do the second go-around. I don't know what they can do. What if the government lawyer says, Your Honor, we asked President Bukele, he said no. What they can do, send in the troops, order the United States to declare war on El Salvador? I mean, at a certain point, you have to sort of just realize courts are limited in their power, right? This is look. I teach common law to students. I tell them this: courts are not gods. They're not deities. Their authority is limited by their jurisdiction and power. They are a coordinate, co-equal branch of government. They're not above the executive branch.
And the guy was a Salvadoran.
He was, yeah. All right. I talked about the Garcia case. Let's move on, and hope you guys are enjoying your lunches. I'm looking at your beautiful spaghetti. I'm like, oh, I wish I could eat that, but I can't. I'm going to be a good Jew this week. All right. DOGE. Who even knew what DOGE was last year at the age of 40? See, I did that, right? DOGE was a crypto meme coin. I don't even understand how this stuff works. It was kind of a joke cryptocurrency, but Elon Musk was kind of partial to it. And after Trump won, he says, we will have a DOGE, a Department of Government Efficiency. The exact contours of DOGE were not clear. In fact, people didn't even know what the hell it was until they did. Shortly after Trump came to office, Trump took this office. It's called the U.S. Digital Service, a random office in the White House. No one even heard of it. And he renamed it U.S. DOGE Service. He just renamed it. And he said, Elon, you're going to work there. And he gave Musk and his musketeers, if you will, or the muskrats, I don't know, authority to basically go to every single agency and scrutinize their spending, and scrutinize their employment, and scrutinize their land contracts, what kind of leases they held. And if you ever go to DOGE.gov, which is one of my favorite things to do, they just post every day the stuff they cut. It's like dopamine fix. Like, oh, they got $1 billion there and $1 billion there. I don't know how accurate their records are. I have no idea, but it's kind of fun to see, wow, how much were you spending on that stuff? These random projects that make no sense, at least to me. So there have been several DOGE-related cases that have already gone to the Supreme Court. Again, we are not even at 100 days yet, right? I think we're at 100 days next week. We're at 90-something days, if my math is right. January 20th to April 20th, yeah. So we're just about 90-something days. This is all. There have been 6 Supreme Court cases at 90 days. This is like making everything else like just look slow by comparison. All right. So the first case involves USAID or USAID. This is how do I describe it? This is the way that U.S. government spends money abroad on a wide range of things that none of us have any interest in. I didn't even know these things existed, a lot of these funding sources. DOGE ordered to be canceled $2 billion with a B, $2 billion worth of funding for foreign policy. Now, if there's any area the president has authority that's broad, it's foreign policy. This is a case where I think that DOGE is on actually pretty good footing. Other cases, not so sure. But DOGE I think has some good footing here to cancel this funding. A number of groups filed suit against the government seeking the restoration of those funds in federal district court. Now, I'm sure you all learned in law school something called sovereign immunity. If you want to sue the government, too bad, you can't, unless the government has waived its sovereign immunity. Now, they've waived it for example, Section 1983, a violation of civil rights, and a few other instances. What about money? Can you sue the government for money damages in federal court? The answer is almost certainly not. What court allows you to sue the government for money damages? I mentioned earlier, the U.S. Court of Federal Claims. This is the court where the government's waived immunity under the Tucker Act. Say, if you want to sue the government for damages or breach, this is where you go. Breach of contract suits are filed in the Federal Claims Court with appeal to the Federal Circuit, and you're in D.C. You are not in federal district court in D.C. So where did the government where did all these liberal groups sue? Of course, they went to D.C. District Court. And they basically obtained a nationwide injunction to block the funding. And then the judge in D.C., Judge Ali, did something kind of weird. He said, you must pay the $2 billion immediately, about like a day that was like within a week. And the government said, look, we can't actually do this. There's so many ways, the mechanism, this and that, we can't put the funds together in like a week. There's just too much to do. We can't unravel what DOGE did. We need at least more time. And the judge said, no, I am not giving you a stay. Pay by Monday. And the case goes to the Supreme Court. And again, the Chief Justice grants a temporary hold called administrative stay. All right? But then the court rules by a 5-4 vote. John Roberts and Amy Coney Barrett in the majority. And they have a very funny ruling. This is, again, compromise, right? Maybe not. The court denies the government's motion, saying we will not block the funding. But, lower court, you should clarify which money is actually to spend right away. Wait a minute. If you deny the government's motion, you can't then give an instruction to the lower court, right? The only way the Supreme Court can instruct the lower court is if you grant the motion, but they denied it. So the court had its cake and ate it too. They said, okay, we're going to rule against the government, but lower court, you should really be a little more precise what they have to actually spend. Go have a hearing and then do some other stuff. So it was this weird case where the court granted relief without granting the motion. They wanted to see in the headlines, oh, we're not ruling for Trump, but they actually kind of did rule for Trump in a weird way. This is a bizarre case, 1-5-4. Again, Justice Kavanaugh was with the conservatives on this one. So at least this case seemed to say that jurisdiction was proper to challenge spending cuts in federal court in D.C. But then we get another case about 2 weeks ago called Department of Education versus California. This was a blocking of $65 million in grants for teachers, and they relate to DEI and other activities. A federal court in Boston blocked the funding. Why is a court in Boston blocking funding for California? Oh yeah, forum shopping, right? Everyone sues in the First Circuit because there's 0 Republican appointed judges in the First Circuit. you have a 100% chance to run a good panel in the First Circuit. Congratulations, better than the Fifth Circuit. Right, our odds are almost 50-50, right? But then this case goes to the Supreme Court. And what happens here? By a 5-4 vote, Justice Barrett majority, the court says, you are in the wrong court. You should be in the Court of Federal Claims. That's where sovereign immunity has been waived. Wait a minute, my brain just got scrambled. In the US 8 case, Barrett said, yeah, you can sue in DC court. In the education case, he said, no, you have to sue in Federal Claims Court. How do you reconcile them? I don't freaking know. I don't know what Justice Barrett's saying. Maybe she doesn't know either, right? I don't know. These cases are at odds, 180 degrees apart. But at least the rule now is all these funding cases should be brought in the Court of Federal Claims, which is fine. I think it's correct, proper. By the way, you cannot seek a nationwide injunction in the Court of Federal Claims. That's not a thing there, right? That doesn't exist. So these cases will proceed deliberately in the normal course, and no more Supreme Court appeals frantically. I think the court was saying, leave us alone with these funding cases. We don't have to order the government to spend all this money. Okay. Number 5, you're almost done with your lunch, perfect timing. The firing of civil servants. This was one of the weirdest cases of all. Okay, so anyone here worked in the federal government or worked in the Fed before? Okay, were you probationary at one point? You don't remember.
I worked for the judiciary.
I know, the executive branch.
Yes.
So you were probationary at one point? Same here. I was a federal employee many years ago. Your first year or two, you're what's called probationary. What that means is during that year, you don't have, you have very few civil service protections. It's actually fairly easy to remove a probationary employee. After you gain your what's called tenure, you can't fire you for anything. It's almost impossible. Why? You have all these protections. You have the Merit System Protection Boards. You have these hearings. You have due process. You have a million different ways that you can't fire the worst employees in the world, right? You can't get rid of these people. So what did Trump do on day one? He said, okay, we're going to just fire all the probationary employees at will, adios, farewell, bon voyage. You're probationary, you have no civil service protections. Somehow, a judge in San Francisco said, no, we're going to block the firing of these probationary at-will employees. There was no power to do this. Right? There was no basis to do this. If people are fired improperly, there are different civil service avenues to challenge their suspension. They can go through MSPB, different agencies. But the federal judge in San Francisco said, yep, we can't do this. The government argued again, there's no jurisdiction to do this, right? The courts don't have this power. Then the Supreme Court had a weird decision. In a case called OPM, that's the Office of Personnel Management versus AFGE, the All Federal Government Employee Union, it's a union. The court held that there was no standing. That the groups that brought this were various states and various unions, and they didn't have standing. Maybe the individuals might have standing, but they can't go to federal court. They have to go seek appeal through the regular board. So again, the court's saying, all right, Trump, we don't like what you're doing, but yeah, you can kind of do this. These probationary workers don't have any standing, okay? So the court blocked that termination, and there were about 16,000 probation employees who were fired, and probably many more will be fired as well. So again, if you're trying to keep a scorecard, the court hasn't ruled consistently for Trump. They haven't ruled consistently against him. It's been something of a mixed bag, and I don't know that we can even generalize yet. I'm still waiting on the Birthright citizenship order and the removal power order. Those are the big ones, right? I consider also other stuff like low-hanging fruit. Like, do we really care about probation employees? Not really. Do you really care about DEI funding in California? Not really. But citizenship, oh, that's big, and firing of these executive branch officials, that's a high value target, as they might say. So let me just sort of close my thoughts and bring a lot of this into focus. We often hear this term constitutional crisis, right? Constitutional crisis, and are we in a crisis? Is there a crisis? Is Trump causing a crisis? This is Germany 1930. Oh, but all the time, law professors. Every day, we are Germany 1933. Congratulations, you know this, but basically we're on the verge of the Third Reich. You didn't know, but we're there. I think this concept of a constitutional crisis is like a coin with two sides. I think on the one side is what we all know, that the executive branch should follow court orders. The executive branch should recognize the court's role in the separation of powers and why following orders is important, right? That's side number one. But slide number 2 is also quite important. It's the courts recognize their place in the separation of powers and realize if they keep issuing orders that cannot possibly be complied with, that diminishes whether courts have this legitimacy, right? Courts themselves can dig their own graves by stepping out too far out of line. And I don't say that lightly. I love the law and I love the courts. But some of these judges were literally ordering planes to turn out in midair and telling the president you must negotiate with a foreign leader, or else forgetting what lane they're in. And Trump, to his credit, said so far that I will follow the Supreme Court. I will take a ruling and I'll appeal it. So how do we equilibrate this, right? One thing to do is granting stays. What's a stay? If a court grants an injunction, that means immediately, as of right now, you must comply with it. Even if you try to seek an appeal from the Court of Appeals, it might take a day or two to follow your papers. During that day or two gap, you are in violation of the law. In theory, you can be held in contempt of court. I think, and I've come to this somewhat begrudgingly, when district court judges issue orders against the executive branch, there should almost always be at least a temporary stay. A stay at least to get a Court of Appeals to rule on it, even a day or two, right? I think there's a hubris to say that I am a single district judge sitting in Boston or San Francisco, and I will dictate national policy. At least let the Court of Appeals get a say in it, and at least let the U.S. Supreme Court have a say in it as well, right? The flip side is the Supreme Court should be more willing to grant stays against the executive branch, right? When there's a policy that can go into effect in a month or two, no one's really in a hurry. When there's a policy that's like in effect right away, there's airplanes are on the tarmac, they're gassed up, ready to go, maybe the judges should just be pulling back. I think that's what the Chief Justice is trying to do. I think for the most part, he recognizes that Trump is probably pushing boundaries, but he also sees that these judges are pushing boundaries as well. Roberts made some headlines when he spoke out against Trump. Trump said that maybe some of these judges should be impeached, like Judge Boasberg. And I think that's silly. That Boasberg did nothing that was impeachable. I think he could exercise poor judgment, but I don't think he should be impeached. But what Trump said that, these judges should be subject to a political process, behaving politically. Roberts said no. The tradition in this country is not to impeach judges, it's to appeal, the appellate process. Okay, John Roberts, let's do the appeal process, right? But that means that these judges have to let the appeal take place. You can't issue these national injunctions without getting any chance to appeal. Let the Supreme Court have the final word on these matters, and then we will all be better off. But these judges, I think, are just, I don't use Trump derangement syndrome. I think Trump really messes with people. He scrambles them. And they do things they would never do in other contexts. Again, Trump does stuff that's never been done before. I admit that. I freely concede that. There's a lot of it I don't agree with. But he's the president, right? He has the power, right? Judges may say, well, the DOJ lawyers are not being forthright with us. They don't get the presumption of regularity. No, that's nonsense. This presumption of regularity is afforded not because the lawyers are behaving this way or that way. It's because of the executive branch, right? Justice Jackson, if you read her dissent in one of the cases, actually referred to the government as a party. The U.S. government is just a party, and a party get really. No, the United States is not a party. It's the sovereignty, right? This is our government. I think the court must treat them in this fashion. All right, there's much more I can say, but I know, Crystal, you have a very active group, and I welcome your questions. So thank you so much for your attention, and happy to hear your thoughts. Thank you.
I'm going to go back to your first topic on removal power. Admittedly, I haven't kept up with these cases in recent years, so maybe this is just a very easy explanation. But at least, kind of from my distant following of the removal cases, it just seems to me like the same, if not the same, almost the same question keeps coming up, but it's all you have to do it for each agency. And
Yeah.
I don't understand why the constitutional question doesn't just answer it across all agencies, because there was the Collins case, I think like 5 or 6 years ago, was CFPB and FHFA.
Yeah.
And they decided, okay, yeah, the president has removal authority. You got to do it again with the SEC. You got to do it again with the FCC. You got to do it again with the EEOC.
Yeah.
The authority is what it is.
Right. So I'll answer Chris's question in a couple different ways. One is the Chief Justice likes to be a minimalist, right? He decides only as much as he has to. So as a result, we've had about half a dozen cases during his tenure about removal power. All of them had tiptoed around Humphrey's executor, right? They've never addressed it squarely and leave these issues there. Now, why does each case have to resolve piecemeal? Each statute is actually slightly different about what grounds are removable possible. Some are like abuse, neglect, abuse of discretion. There are different standards, slightly different. I think what the courts simply do is overrule Humphrey and say the president's removal power is absolute. Period. Full sentence. Doesn't matter what Congress says, and that cleans it up. The court, though, doesn't give us these sorts of clean rulings. They always do things piecemeal, so I'm not optimistic we get a definitive ruling. But then again, was it the SEC? No, the FTC, the FCC, the NLRB. I can't go through the acronyms again, right? They're all there. The harder one, though, is the Fed, Federal Reserve, right? If Trump tries to fire the head of the Fed, that might be different. In fact, even Trump has said basically if the Fed's different, like federal monetary policy is maybe different. That's the big one if he tries to influence the federal policy. Other questions? Yeah.
Are there any instances in American history where the executive just outright defied the Supreme Court?
No, and I'll give you two examples that are not true that you probably heard of. So one you've probably heard of is Andrew Johnson, who he told Mr. Chief Justice Marshall, "You made your ruling, go enforce it." Never happened, right? It's apocryphal. I'll tell you why it never happened. The case was called Worcester versus Georgia. The case wasn't involving the U.S. government. There was no actual order running against the government, something from which to ignore. So it never happened. The second myth, which is again is not true, involves Abraham Lincoln and the Civil War. There was a case called Ex parte Merryman, which occurred during the Civil War. Lincoln, you might recall, suspended the writ of habeas corpus, which means you could basically detain people without any sort of hearing. Chief Justice Taney had a case involving a person detained in Maryland. Taney never actually ordered Lincoln to release the prisoner. Lincoln did not release the prisoner, right? So Lincoln did not ignore the order, okay? But Taney did rule that habeas suspension was unlawful, and Lincoln did not agree. Now I'll give you an indirect example where there was defiance, but indirectly. You know what it was? Dred Scott versus Sanford. It's true. What did Chief Justice Taney rule in Dred Scott? He said people of African descent could never be citizens. Never be citizens. What did the Lincoln administration do? They gave passports to free blacks. Is that in defiance of Dred Scott? No. Why? Dred Scott was a conflict between Dred Scott and Sanford. This was a conflict between two different parties. The U.S. was not a party. So if you're asking me, has there ever been a direct defiance of a direct court order by a president? The answer is no. I don't think so, at least. But there have been peripheral areas where presidents have registered their dissent. I'll give one last case. Ex parte Quirin, Q-U-I-R-I-N. This was a crazy case from World War II where these Nazi spies washed up in the shore of New York. And they were intended to infiltrate the United States. Instead, they turned themselves in. They went to the FBI and said, "Here, please arrest us. We don't want to go back to Germany. We'd rather be in an American prison than be in the German government." FDR tried them as basically enemy combatants in a war tribunal. If you ever go to the SG's office, the DOJ building, the Solicitor General, there's actually a conference room where they tried these aliens. The case goes to the Supreme Court. Was this military tribunal proper? Roosevelt told the court, "I don't care what you all do. I'm executing these people." By the time the court issued a decision, they were already executed. Right? The court is just like, sure thing, yes, this is proper, and they have an opinion later, but Roosevelt's like, "I don't care what you, I'm executing these guys. This is my power, not yours." So I can go list after list of instances where there's been a clash, and the court exercised the better part of valor, which is discretion, and didn't have a confrontation. So far, the lower court judges haven't quite gotten that memo, but I think the Chief Justice gets it, at least for now, but we'll see what he does. I don't know.
Yeah, well, is that why in Komatsu I've always felt like, that's when they interned all these Japanese American citizens. And I've always thought that was, well, later they paid, Congress allowed for reparations, I think $25,000, a person who was still alive back in the late 70s, early 80s. Was that a point where the court had to, because it was a wartime, and you know what? Tough shit. It's like we're gonna have to go. Wait. We know the president's gonna do what the president wants to do. We've got to exercise discretion to keep ourselves. Because if they had gone the right way, I would say, which is Komatsu, you can't be interned. That could have removed or made Supreme Court lesser or something, because it wasn't gonna be happening anyway.
So let me tell you the true story of what happened in Korematsu. No one knows this. In fact, Justice Jackson doesn't know this. Justice Jackson had the chutzpah, if I may, to say that Korematsu was better than the Supreme Court's ruling on the El Salvador case. At least that was done in the open, right? This was not done in the shadow docket. She's so wrong, it's not even funny. So there were 3 cases involving Japanese detention during the war. Hirabayashi, Korematsu, and Ex parte Endo. There were 3 separate cases, right? Hirabayashi upheld a curfew that said basically people of Japanese descent had to stay in their homes. The court upheld that. Korematsu is actually not about detention. Korematsu is about exclusion, saying that if you lived on the Pacific coast, you must be excluded into the interior. Ex parte Endo concerned the detention in the camps. No one knows this. In Ex parte Endo, the court held that detention was unlawful. Did you know that? In Ex parte Endo, the court said the government can't detain people in the camps. I'll explain in a minute. Korematsu said you can exclude them from the coast, but the Endo said you can't detain them on a weird statutory issue. But why did this not matter? When the court ruled you can't detain them, what about the camps? By the time the court ruled in Ex parte Endo Korematsu, the camps had already been closed. No one knew that, did you? I'll tell you one more. The Chief Justice knew about this and held the opinion until Roosevelt issued the order to suspend the camps. So the case was a ruse, right? The court upheld this broad power of exclusion, knowing that Roosevelt already terminated the camps. So you want to talk about collusion between the executive branch and the Supreme Court? Go look at Korematsu. That case has a fascinating history.
Well, it's kind of near and dear because, interestingly enough, there's only one German intern in camp. It was actually in Crystal City. There's a great book called The Road to Crystal City, and it was about that. And I kind of know about it because people who spoke German were in Livonia and Seguin. And
that's right.
my mother growing up, even though all of them spoke German, she was told, she was born in early 30s, that we can't do that. We can't talk about German. We can't discuss German. Because they didn't want to be rounded up with some people from Livonia and Seguin and taken to Crystal City. And so I've always seen that as kind of a blight on the American public. But I do distinguish that from what's going on now because these are U.S. citizens. So.
Fascinating. I kind of knew that, but not that particular story about people in Seguin. Otherwise, but you're right. Yeah, very good question. Thank you, sir. What other questions we have? Yes. John. Yeah. Go ahead.
Where are we going to end up on the larger issue? I know there's a lot of skirmishes, but the larger issue of executive versus congressional authorization of spending.
Right. So I didn't mention the I word, which is impoundment. I didn't get to it, but maybe I will now. So far, the stuff that Trump is cutting is what's called discretionary funding, right? Contracts can be terminated at will, right? You have termination for cause and termination at will, different types of breaches. So far, they're going after the low-hanging fruit, right? Where the contract base says, yeah, you can cancel this for any reason at all. For convenience, if you will, terminate for convenience. The bigger issue is impoundment, where let's say Congress appropriates $1 billion to spend on something, and Trump says, no, I don't want to do it. He hasn't done this yet. He almost certainly will. I tend to think this is not going to be proper. And putting apart the Constitution, something called the Impoundment Control Act, which was signed after Nixon, which seems to suggest that the president must spend money that's appropriated. Trump might argue that statute is unconstitutional. In fact, Nixon argued it was unconstitutional. I think Trump will probably lose in this one. Federal legislation is the supreme law of the land. It's a statute. I think you have to enforce it. Now, with one caveat, if Congress says you must spend money on something unconstitutional, I think that could probably be disregarded. So, for example, Congress says you must spend this money to go invade some foreign country and conduct battle this way. I think he probably would be able to decline to spend that. Or let's just make an example. Congress says you must spend this money to open up segregated schools. You can't do that. So I'm giving sort of extreme examples, but most spending is just, we would say, stupid but constitutional. And I don't think you disregard it so easily. You had a question in the back?
Where do you come out on the meaning of and subject to the jurisdiction thereof and the citizenship clause?
Yeah, good question. I researched this issue years ago. I'd op-ed in the Wall Street Journal on this in 2017 or 18 or so, during the first Trump administration. I think that children are legal aliens or citizens at birth. I think subject to the jurisdiction and subject to our laws. If you're here illegally, you're illegal, but you're still subject to our laws, and you can be removed for that, right? I think your children are as well. So I don't think this is actually a particularly close call, but I think there are some good arguments on both sides, and the court's never settled it. On the current court, maybe Justice Thomas goes along with this, but not much more than that. But I think there are some good arguments going back to the 1860s of why these children would not be citizens. But if nothing else, there's been kind of an unbroken practice that's been liquidated, where people have been citizens for so many years. I think you have a very good reason why you come out a different way. That's my view, at least. What questions we have? Nothing else?
Thank you very
Thank
much.
you.
Thank you so much.